When I was getting ready to go to work on July 7th, 2016, if you would have told me that I would be attacked by a mob, arrested, held on felony charges, slandered in the media as some sort of violent, dangerous white supremacist, put through a trial where most of the exculpatory evidence was ruled to be inadmissible, and that a bevy of due process violations would be committed against me, and that I would be found guilty of 21 counts for not harming a fly, trying to avoid an altercation, and preventing a gang from beating and robbing me, and that I would have to take my case to the United States Supreme Court to clear my name, I would have told you you were insane. But here we are. It's September 1st, 2020, and 4 years after the incident in question, my case is now headed to the Supreme Court of the United States. The Oregon Supreme Court has denied to hear my case. In our initial brief to them, we cited conflicting case laws that relate to whether or not a defendant's mindset is relevant in self-defense. The Supreme Court has opted to leave this vague and undefined, and these standards can now be applied in various different ways depending on how a prosecutor or, some certain attorneys or judges happen to feel on a certain day. In fact, we've based a lot of the overall appeal on the fact that all of the evidence relating to my mindset, my training, my experience, my knowledge, my studying of Antifa and these other, anarchist organizations over the years was all ruled to be inadmissible. So not only is that exculpatory in nature, as in evidence that weighs in my favor, but it also factors into a concept known as mens rea, which is the knowledge of culpability in a crime. Now that is a necessary element for prosecutors to prove someone is guilty. Except the prosecutors themselves argued that most of the evidence relating to mens rea should not be admitted. That's just a contradiction there. Further adding to the absurdity, just last week, the state Supreme Court overturned a rape conviction because a woman saying, "No, I don't want to," isn't enough for an accused rapist to knowingly understand that she isn't consenting. They're essentially allowing the mindset of a rapist to be considered, but not the mindset of someone citing self-defense. I'm going to make a separate video on the rape case as soon as I'm done with this one, so look for that one. So now my case heads to the federal Supreme Court, and I am fortunate enough to have a top-notch team of attorneys headed up by Robert Barnes. And I'm not just fighting for my rights and my reputation. I'm fighting for everyone's rights. Not just as it relates to the Second Amendment and self-defense and firearms training, but as it relates to due process and prosecutorial abuses. At its core, does a gang of thugs have the right to use force, threats, and intimidation to prevent a person from being in a public area engaging in their First Amendment rights to freedom of the press? The courts say, yes, it's not unlawful for a gang to do that. It's unlawful for you to stop the gang from doing harm to you. Can a district attorney cite a false police report and lie to a judge in front of media by claiming someone has ties to white supremacist organizations and was threatening someone else in an entirely separate matter without a shred of evidence to support it, and with a report that's so weak that the DAs themselves never pursued it beyond that point, and use that to unduly influence and taint a jury pool? According to the higher courts in Oregon, yes, they can. If they can do it to me, they can do it to anyone. They can take a black defendant and make claims that he's a child molester, he's a pedophile, he's a child sex trafficker, he has ties to these street gangs, he's been rumored to be involved with, drug dealing and all these other things, without a shred of evidence to support it. And they can use that by broadcasting it to the media and use it to unduly taint jury pools. It's perfectly acceptable right now, according to Oregon courts. Should prosecutors have to explain which part of a law they are charging a defendant with when that law has multiple different definitions? No, not according to the courts in Oregon. You're left with an impossible defense because you don't know what you have to defend yourself against in court. And as of now, the prosecutors don't have to specify it. Should someone's own voluntary statements to a detective be ruled admissible? Usually this is the other way around. Usually it's the defense that wants those statements to be inadmissible, and the prosecutors want those statements to be on the record. In my case, we wanted those statements that I gave to the detective voluntarily to be part of the record, admitted into evidence, because I explained to the detective how the mob was coming after me, how they encircled me, how I was in fear, how I was acting in self-defense against the mob. And the DAs didn't want those statements on the record. So as per the Oregon higher courts, those statements are inadmissible. So this means you could also play it the other way around now. You could have a murder suspect or a rape suspect who confessed to crimes or gave certain key information to detectives. Now they can use, the defense attorneys for those guys can use this same standard and get those statements wiped from the record. That's inadmissible. It'd have to be if you're playing it the same way. So essentially, the arguments of DAs Kate Molina and Todd Jackson are going to help rapists and murderers avoid prosecution in the future. Can a judge rule that a defendant's prior injury, where that person had 2 cameras stolen and was body slammed onto the pavement, thus adding to a person's heightened sense of fear when staring down an even more precarious scenario just a year later, is somehow not relevant? Can judges believe they are mind readers and not be very good at it? Can someone be threatened with imprisonment for engaging in what used to be First Amendment rights? According to the Oregon courts, yes, they can. When I say my case invalidated the First Amendment, that's part of what I mean. They can ban me from working and throw me in prison if I engage in certain what used to be First Amendment rights. If they can do it to me, they can do it to anyone. Now, this seems to contradict some recent federal rulings here in Oregon. Again, this is the summer of 2020 here, so we've been going through all the riots lately. And apparently a bunch of the people who were arrested and held on federal charges were initially ordered that they could not attend protests. Now, that was part of the orders that had been placed on me. And federal judges recently overturned that for those people awaiting trial. So now, once again, you have this contradictory case law thing where it can be applied different ways to different people, depending on the moods of the people involved. Can a judge insert his own mindset in place of a defendant's mindset? Can a judge refuse to consider self-defense by stating that the actions of the other actors were irrelevant in regards to how a defendant reacts to it? According to the Oregon Court of Appeals and the State Supreme Court, yes. All of these things are perfectly acceptable. If they can do it to me, they can do it to anyone. This could be you. This could be your family. This could be your loved ones. This could be your coworkers. This could be your doctor. This could be your accountant. This could be your veterinarian. So that's why I continue to fight, and I'm not going to stop until this case gets overturned. I'm not just fighting for my rights, I'm fighting for everyone's rights. And I have no doubt that DAs across Oregon have been using these shady, unethical, immoral tactics to lock up innocent people for years. All of these little justice reform nonprofits that are around should be jumping all over themselves to help me out in my case, because this is probably their best chance to get these practices overturned and nullified so that no one else has to endure this. And here comes the part that I hate. You may have seen this before. I don't like this part. People who know me know that I don't like doing this. I have too much pride to do this, but, begging for money. I'm not good at it. I don't like doing it. It's embarrassing. But this costs money to bring a case before the Supreme Court. Not only have I been out thousands of dollars from when my arm was shattered, and now I'm left partially disabled, unable to go back to my old line of work, unable to do, heavy, laborious manual labor things. Not only was I banned by the courts for 4 years from doing my work in journalism, And not only have I had to cough up thousands upon thousands of dollars in attorney's fees, legal fees, probation fees, and on top of this whole COVID thing that's wiped out probably 3/4 of the work that I've once again found myself, trying to get into a new line of work. Now I need to cobble together money to take the case to the Supreme Court. I guess I take solace in that all the money goes to the attorneys, it goes to the legal fees. It doesn't go to me, and I don't feel like too much of a schlupp here. Because the last thing I want is charity from people. I'm not big on sympathy. I have too much pride for that sort of thing. I do have a fund set up on PayPal under Strickland Legal Fund at gmail.com. I'll put a link to that in the description. You can also donate through Oregon Firearms Federation. When you go through their checkout page, make sure you put in a note there that it's for my legal fund, and they'll make sure that gets allocated towards that. I'll leave a link to their donation page as well in the description. You can also hire me. I like working. I like, being constructive, doing, constructive things for money. I do professional video work, professional sound work. I used to do concert sound, again, until my arm got shattered, and now I can't lift big speakers and push road cases up and down ramps anymore. I do ads for, broadcast, for online, small businesses, nonprofits, campaigns. I do weddings. I can film, live events, corporate speeches. I can implement, PowerPoint presentations within your speeches and whatnot. Reach out to me. Hire me. I'm looking for work. And for those of you coming across this video by pure happenstance, I was the news videographer who was attacked by a gang when I was out filming a protest in the summer of 2016 in Portland. This is before all the riots were regular. This is before violence was commonplace. This case actually set the standard for mob violence being legalized. I was the one arrested. I was the one found guilty of 10 felonies and 11 misdemeanors for trying to defend myself against the mob that was attacking me. I encourage you to check out the other videos here on my YouTube channel. I have several videos about the case, a lot of audio from the trial and other proceedings. I have the multi-synced videos from the actual incident. And you can also look at my past work. I used to film political events in the area, and that eventually blossomed into my actual job. So that's how I got caught up in all this. And yeah, I've got all these videos about the case and the trial and contradicting things, lies told by witnesses and DAs, and just all sorts of shady shenanigans that have gone on throughout this whole ordeal. If you don't have any money, if you can't donate, I understand that. You can help out by sharing some of these videos, sharing my story, getting word out about this. The more awareness that's raised, the more attention that the case gets, the better I feel going into it all. So thank you all for your support, and I'll keep fighting.